I remember the day of a trial within a trial. I remember it very, very vividly when Judge Ratha gave his ruling, not judgment, but ruling on the trial within a trial. I remember it so vividly because I said I wasn't going to watch anymore the trial. I was very, very emotional. I felt there was a lot of injustice around it. I couldn't believe Judge Ratha would admit those statements. But here we are. We all know he did. And that was March 2024. So yesterday I posted a video. Those of you who got to watch it, I posted a video reacting to the Eyewitness News interview that included Khomotso as the moderator, Bongani Masugu, official minister, the TikToker, as well as the legal analyst Siavi. I made a mistake again, guys. I don't know why. Okay, it's got to do. It's a jumble jumble in my head. Okay, Siavi. I got it right. I got it right. Okay, oh, Ugavelo Siavi. Okay. So I was reacting to that. I don't know what to call it. Podcast that they did, and I was reacting, and the fact that the legal analyst or the legal expert Ugavelo Siavi said the confessions by accused number 1 and accused number 2 were going to be a very, very big problem. Very, very big problem. So this is part 3. This is now where we listen to what Judge Ratha said that particular day, which I want you guys to take time to listen to. It was very hard for me to go back. I watched many clips of the SENZO MEYIWA trial. This one was hard for me to go back to, and I still had the same emotional reaction to it. So the purpose of this is we know when they resume court, we are either going to hear if legal aid is going to fund the 174 application, as well as if they do, what is Judge Ratha's going to be his decision with regards to the application for 174. If in order for them to go forward with application for 174, they're saying the state, they have no case to answer to, and the 5 accused must be discharged from the charges. The legal analyst in that podcast by Eyewitness News. I'm so bad with acronyms. Eyewitness News said that the 2 confessions were a huge problem, and he did not see how Judge Ratha was going to grant the 174 application when there's actual confessions that are being referred to. I'm going to refer to Judge Ndim for a quick second. Okay, Judge Nathan Erasmus over there in the Western Cape. He never, ever, ever, although he admitted the confessions, he said he was admitting them in that trial, and he said he didn't want anyone to refer to them as confessions. So from then on, they became referred to as statements, which is a stark difference in the SENZO MEYIWA trial. They're consistently referred to as confessions. So let's listen to Judge Ratha give his ruling. And I need you guys to watch this all the way to the end. Watch it all the way to the end, and then go ahead in the comment section. Let me know your thoughts. Do you still disagree or agree with the legal analyst, depending on which side of the spectrum you are, that the 174 application is not going to work because the confessions were admitted by Judge Ratha? And again, I need someone to tell me the exhibit numbers of those confessions, because the fact that they have exhibit numbers, I want you guys to realize that those exhibit numbers represent that they have been handed up to the court. So remember, guys, anytime anything is handed up to the court, you always hear the attorneys, whether they agree or not, okay, they always say, as it pleases the court, which means that's it. There's nothing they can do in that moment. Of course, there's appeals and dun-duns that can be done, but in that moment, they respectfully say, as it pleases the court, and then they move on to the next phase. So the point I am getting to is confessions were admitted until the very end of the trial, when Baloyi said, listen, state has closed its case. Those confessions were still part of it. The exhibit number tells us that they're there. The defense didn't say, oh, yes, and by the way, you got to strike those off the record. That didn't happen. So they are part of what the judge will use to make his decision in the 174 application. Respectfully, I hope we can. Let's listen to this. Let's listen to this. Okay, I'm giving a long intro. I want you guys to listen to this, and then we'll talk after. Okay, please stay till the end. very important. I barely ever ask you to stay till the end. This is one video I'm asking you to watch all the way through, and then we comment. Okay? Thank you.
As before,
Yes.
the matter has been adjourned to today for a ruling on the admissibility of the confessions and the pointings out.
Yeah, that is correct. And I'm pleased you're repeating what I said. It's not a judgment. I explained. I quoted the law. It's a ruling. Can you just read for us section 217? Is that A, for the confessions allegedly taken by Colonel Mboto and Raputi.
Rapadu.
Rapadu. That's Rapadu, ne?
Yes.
And Mrs. Kronje.
Koronye, yes.
And then also read the 219.
298, yes.
219. 218, sorry. 218, so that you refresh our knowledge. Right, that is the law. So it mustn't be argued that this judge didn't consider the evidence regarding coercion. In other words, the synopsis of the encapsulation of the evidence, the salient features are this, that when the state intended to bring into play by introducing the so-called alleged confessions or statements of accused number 1 and 2 and the pointing out by accused number 2, the defense objected. And the principal objection was that, 1, they did not make statements. They did not make confessions. They were told to sign documents which were fully completed, and they were told sign here, sign there, initial here, initial there. That was the initial defense. The second defense is that they were assaulted, tortured, severely, as Mr. Mgomezulu put it, severely tortured, choked, electrocuted, kicked, in order to elicit their signatures on the documents. In other words, these accused before court, their evidence is they don't know the contents of the confessions. They don't know. They were never read to them. And if you go further, accused number 1, for instance, says when he went to sign the confession or statements before Maboto, I think, Maboto never even sat down. When Maboto came, they were assaulting him. All that group of policemen. And Maboto then called him aside and said, hey, you know what? Why don't you sign these documents? These guys are going to injure you. And then, to save his life, accused number 1 says he signed. No discussion with Maboto in an office sitting down, according to accused number 1. Accused number 2 also says when he went to sign the alleged confession or statement before Mrs. Kronje, all he said when he got in, even before Mrs. Kronje could introduce herself as a magistrate, he came in and told Mrs. Machaping, the interpreter, that, may you tell the lady, please, that 6 weeks I haven't had a bath, from the 16th of June, I think. And also that I want to speak to my daughter, I want to speak to my partner or parents. And that was it. And he sat down and looked at the ground. And Mrs. Kronje, what he did was, he was busy with his computer. She never asked him anything. All she was interested in was the computer, and then she would get out and gossip with a fellow magistrate or fellow white lady and come back. Mokhono was going in and out, consulting with Mrs. Kronje. Nothing was discussed between accused number 2 and Mrs. Kronje, except, as I said, that I haven't had a bath and I want to speak to my daughter and my partner. Nothing. The same applies for Rapudu. Accused number 2 says, no discussion with Rapudu, nothing. He was just beaten up and told to sign. So in the main, that is the salient aspects of the evidence relating to the trial within a trial. It's obvious that Keninda, Maholewa, and others gave evidence. But what I want us to understand is that this court, after careful analysis of the evidence adduced by the state, and after careful analysis of the cross-examination interposed by the defense against the evidence adduced by the state, and after careful analysis of the rebuttal evidence of accused number 1 and 2 and the cross-examination interposed by the state, And after careful analysis of the heads of argument by all the parties concerned and the verbal submissions made by all the counsels in this court, I have dealt, not like this magistrate did, I've dealt with all the evidence relating to whether the said alleged confessions were made freely and voluntarily in the sound and sober senses of the deponents without any force or coercion. I've dealt with all that. And I've also dealt with the other primary defense by the accused, that all the accused were not apprised of their constitutional rights, meaning section 35(5) of their rights. They were never apprised according to that. And this court even also interrogated that. And as we all know, section 35 encapsulates the concept that if any evidence is acquired through the infringement of the Bill of Rights, that evidence should not be admitted into the record of the proceedings relating to section 1(7) and section 1(8), even section 1(9) of the Criminal Procedure Act. Right. Consequently, after going through all that evidence carefully, this court has reached the following conclusion. One, it rules that the confession made by accused number 1 was made freely and voluntarily without any coercion when accused number 1 was in his firm, sound, and sober senses. 2, the confession made by accused number 2 in respect of the said confession being taken by Mrs. Ronje, the magistrate, the court rules that it was made freely and voluntarily without any coercion when accused number 2 was in his full and sober senses. And also the confession made before Colonel Rapudi was also made by accused number 1, 2, freely and voluntarily without any coercion when he was in his sound and sober senses. And also the pointing outs made by accused number 2 before Colonel Khadebe were also made freely and voluntarily without any coercion when accused number 2 was in his full and sober senses. Okay, that is the ruling. Yes, Mr.
My Lord, may we perhaps adjourn for a short while just to...
As my Lord clearly explains, it's not a judgment, it's a ruling. Therefore, if the circumstances change, he can also change his mind. But you heard at the very end, as I explained before, that the legal attorneys all said as the court pleases, because there's nothing else they can say once a ruling or a judgment is passed within that court. It is as the court pleases, and they even go further to say, I am indebted to the court, even though, you probably have your fists clenched and you're just not happy about it, but you have no choice. They have to acknowledge the judge and say, as the court pleases. So members of the jury, I have brought this to you for us to review one more time because of the comments on the video I did yesterday. A lot of people were against the legal analyst in that podcast and saying, no, the confessions were not taken freely and fairly. My Lord says they were. He has not come back to tell us otherwise or that he has changed his mind. I understand, okay? I understand. In the court of public opinion, those confessions were not given freely and voluntarily. But my Lord has put it on record in the SENZO MEYIWA trial, in case this goes somewhere else, like he likes to say. These confessions were made freely and voluntarily without any coercion. And accused number 1 and 2 was in his firm, sound, and sober senses. And not only just the confessions, my Lord also accepted the pointing out. So I'm going to end this video here. I'm not going to drag this out. This is the confession conversation. The confessions are a huge problem for Section 174 application. You know it's an application, which means omnisi wemvula. Ramasipili, Sipo Ramasipili, Advocate Zithulele Nxumalo, and Advocate Zandile Umshololo are going to put forward their applications. So they're going to speak. It's not going to be, we're doing section 174, and then the judge says, okay, yes, 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 or no. And Balo is also going to also present his opposing to that application. And we're going to have to listen to it. So it's going to go on for a few days, in my opinion, I think, before the judge makes another ruling on their application. So let me know your thoughts in the comment section down below. I know this is a tough one to swallow, but we must follow the law. We must. It is the law. It is what it is. We can't change the law. But we can ask Mkhwanazi to sit in there just, to make the judge jog his conscience at the very least. That is it from me today. If you made it this far in the video, thank you so much for watching. Please share this video so that more people get to find out about the confessions and why the confessions are a big problem in this application. I can't wait. I don't know the answers. I don't know if the defense is really going to do section 174. I don't know if legal aid is going to pay for it. I don't know what Judge Ratha is going to do. All I can do is bring you the cases that I have watched and stuff that I've observed. So yeah, that is it from me. Thank you so much for watching. I'll catch you on my next upload. Have a great day. Bye. Mzansi Unfiltered, checking out. Catch you on my next upload.
My Lord, I'm indebted. Yeah. As the court pleases, my Lord, I'm indebted. Yeah.
If the grooves don't fit, acquit the 5 accused. Mnisi has done a fantastic job proving there was no match.